Hello, this is Josh Findlay, Director of the Texas Public Policy Foundation's National Election Protection Project. And here we are with the Election Protection Podcast, where we talk all things election integrity. We're joined today by Heather Honey and Karen DiSalvo from the Election Research Institute. They provide litigation support for election integrity issues. And we've got a very important case to talk about today. We're going to talk about the Keever versus Biden case. Now, for our listeners that don't know a lot about this case, we're going to dive into it. But one thing that's particularly interesting here is that this is the first, and to my knowledge at this point, the only case to challenge Biden's executive order requiring government agencies essentially to run voter registration drives. This is a new thing for the federal government to institute. And so we're going to dive into that a little bit today, along with the lawsuit that they've filed challenging it. Heather, Karen, it's great to be with you.
Thanks for having us.
Wonderful. Now, usually on this podcast, we skip introductions. I don't do it. I give you the chance to tell a little bit about yourselves, your backgrounds, why you got involved in election integrity in your organization. So, Heather, why don't you start with a brief introduction, and then we'll go to Karen.
Sure. Yeah. So I am the executive director of the Election Research Institute. We are a 501c3 nonpartisan organization that does training, education, awareness as it relates to our election systems. And we also, as you mentioned, we provide litigation support for cases where we think that, there's a case to be had to try to resolve some vulnerabilities in the election system. And so my background is in investigations. I do investigations, I do training. I train other people how to do investigations. I do some analyst work, and I'm also sort of in my free time, I do supply chain audits and operational efficiency audits as well.
And my name's Karen DiSalvo. And first of all, I want to say thank you so much for having us on your podcast to talk about this case that we're involved in. I'm an attorney. I've been practicing. I took the bar exam in the 1990s. For the past few decades, I've been working as an educator. But after the 2020 election, I started becoming very involved locally in our election processes. And someone linked me up with Heather. And so we formed this nonprofit, the Election Research Institute, last year. And one of the mission statements that we put together was we wanted to provide litigation support for election integrity cases. And so that's why we're involved in this case. The Election Research Institute is sponsoring this case, and we're assisting in the effort because this is the only case to our knowledge that's dealing with this executive order that President Biden has put into place. And it's an extremely important issue. It looks like it's gaining some momentum now, thanks in part to shows like yours. So I'll turn it back to you now. Thank you.
Well, thanks, Karen. You're exactly right. People are talking about this executive order. It's something that is gaining a lot of traction in conservative circles. So first of all, Heather, if you don't mind, can you explain a little bit about this executive order, first of all, for our listeners that may not be familiar? Kind of tell us what it is, what it does, and how it is being implemented in practice.
Yeah, so for starters, I think it's important to understand where it came from, right? So this was a proposal by the far left organization Demos, and this existed prior to even Biden's inauguration. But shortly after his inauguration, basically word for word, President Biden adopted the language in the Demos recommendation and implemented or signed into, signed in the Oval Office and posted this executive order. It's 14019. And essentially what it does is it commands every agency of the federal government to create a plan to increase not only voter registration, but also to increase voter participation, right? To do get out the vote activities. One of the sort of alarming components of it is that it instructs these agencies to partner with approved non-profit, third-party entities to achieve these goals. And, in Pennsylvania, and we bring this up in our case, a lot of states, a lot of state legislatures, a lot of people recognize the the impact that these, sort of third parties involved in our elections were having in 2020. And in response to the CTCL, CEIR, Zuckerbucks impact in the 2020 election, 28 states have said no more. We don't want that. And so this Biden EO, amongst other things, is an end around that prohibition from third parties, and it's basically thumbing the nose at these 28 states that have said they do not want third parties doing, working with the government in elections.
Yeah, so it's just incredible. I mean, for the first time, this is the federal government running a get out the vote operation, telling government agencies to partner with nonprofits. Can you give us an idea of what some of these nonprofits are potentially? Because I think we can guess the names of some of them.
Yeah, so I mean, some of them we know, but most of them we don't, because one of the other incredibly alarming things about this EO is that the White House is refusing to disclose information about it. So, bits and pieces are leaking out. We've gotten a list of people. FGA has done incredible work in this space, and they've gotten lists of people who were invited to attend the meeting at the White House about the EO, and it included folks like Stacey Abrams' organization, Fair Fight, and the League of Women Voters. But what that list of invitees did not include were any sort of center or right of center organizations that are in the voter registration drive, get out the vote area. So very, very partisan list of attendees, list of invitees, and again, there have been hundreds, I would say. And in fact, there are some lawsuits like challenging the refusal to disclose information through FOIA, right? But Congress has subpoenaed information about who these partners are and what these action plans include. And the White House has basically just said, we're not doing it. And in fact, the National Association of State Secretaries of State, or the NAS, as they call it, had a meeting, and a representative from the White House joined to sort of allegedly talk about this EO. And some of the secretaries said, we would like to see the plans that you have. We would like to see them. And the White House said no, that they have no intention of releasing those plans. They intend to keep them private. I mean, so it's just an unprecedented.
So they wouldn't even give them to the secretaries of state, the people that are in charge of running the elections in most states.
Right.
That's just incredible. One theme that we have here on this podcast a lot is the government trying to hide kind of what they're doing. And it looks like this is just another example of that. So, Karen, can you tell us a little bit about this lawsuit?
Yes, so our lawsuit was filed on behalf of 27 Pennsylvania lawmakers, so 26 House of Representatives members and 1 state senator.
And just a second, Karen, I think that's significant. This was not just your average citizen. This is legislators who see this as such an important issue that 27 of them wanted to sign on as plaintiffs in this lawsuit.
Yes, and basically the basis of our lawsuit centers around executive overreach. And so in the 2020 election and in the lead up to the 2020 election, we saw lots of changes in the way that our elections were being regulated in Pennsylvania, right up even including the night before. So just for a few examples, drop boxes. So our Department of State issued a directive that drop boxes could be used throughout the state. We had, right the night before the election, Jonathan Marks, who's actually a defendant in this lawsuit, sent out an email to all of the election directors in the state that basically allowed for the curing of ballots, so the correcting of perceived defects to ballots, which actually also contradicted state law on the issue. And as a result of the changing of the rules by the executive branch, we've had a lot of confusion in the state of Pennsylvania with regard to what rules should be followed. And in fact, the function of the election rules are supposed to be being created under our constitutional provisions by our state legislatures. And so we have the 2 parts of the United States Constitution, the Elections Clause and the Electors Clause, I'm sure we're familiar now with the times, place, and manners of elections are supposed to be prescribed by the state legislatures. And Congress has the ability under the Elections Clause to regulate to a certain extent. But what we're dealing with here with Biden's executive order is not congressionally approved. This is through the executive branch. And so our lawsuit essentially involves executive overreach through the executive order issued by President Biden, but then also through our Governor Shapiro implemented automatic voter registration, not even through an executive order. He just did a press release and announced that was going to be what we had in Pennsylvania. And then the Department of State. So the Department of State we had any number of selections to choose from with regard to what we were going to include in our lawsuit for the overreach by the Department of State. But in all instances, what we have are at the federal level and the state level, we have executive officials setting the rules with regard to our elections in Pennsylvania. And sometimes the rules conflict with state law. And so that's what our lawsuit in essence is all about. It's about executive overreach at all levels of government.
Well, Karen, thank you for that summary of the case. Can you give us an update about what is happening, the current events?
Yes, we filed a petition for review by the United States Supreme Court, and we filed a motion to expedite. Obviously, we're getting very, very close to the November 2024 election, and we think it's imperative that this issue be heard in enough time to stop this executive overreach from occurring before the November 2024 election. So we are hopeful. We've asked the court if they can take it up for review in May. And so this is, that thousands of cases are appealed to the United States Supreme Court each year, and there are only about 100 that get to be heard. But we think that this case is of such great importance to the entire nation that we're hopeful that the United States Supreme Court will agree to hear this case.
Exactly. So to back up for a minute, you filed the case initially, and then it was dismissed in Pennsylvania, correct?
It was dismissed.
And then now you're appealing it to the United States Supreme Court. So tell us a little bit about why the case was dismissed, because we all hear things about Pennsylvania courts, right? Conservatives can't win anything in Pennsylvania courts. Do you think that this was a good ruling by the court, or at least obviously it wasn't a good ruling, right? But was this a legally sound ruling? There's a real question of law here that needs to be decided by the Supreme Court, or was this just Pennsylvania courts being partisan like they always are, even if they say they're not?
No, I think that there really is an issue of law that needs to be decided in this case. And so this case was brought in federal court. So we brought it in the Middle District of Pennsylvania federal court, and the judge dismissed based on standing. The issue involves whether individual state legislators have the ability to bring cases such as ours. And so the United States Constitution gives the power and the duty to regulate elections to state legislatures. But is this a duty that the legislators have the ability to enforce? And that's what this case is all about. And we do have legal precedent behind us. We have a Third Circuit Court of Appeals case, the Dennis versus Lewis case, where the courts recognized individual legislator standing. And we also have a United States Supreme Court case, albeit an older one. It's the Coleman versus Miller case from 1939. And we believe that the court viewed this issue as an institutional issue, that the harm was to the institution, so the institution itself needed to bring suit. But we see this case as being a case of personal rights. So the personal rights were given to the individual legislators. And if they're not able to bring these cases, then who can? I mean, since the 2020 election, we've heard the claims, 64 lawsuits, and many of those, you'll hear people say that there was no evidence of fraud, and they'll point to these 64 lawsuits. But what people don't realize is that the majority of those cases were dismissed based, just like our case, on lack of standing. And so the court said that the individuals that brought this issue to the court didn't have the ability to bring that issue before the court. And so that's what standing is all about. And we believe that we have a good claim for standing. We have precedent behind us. And we just need the court to definitively decide that the Coleman case, and in Pennsylvania, in the Third Circuit, that the Dennis v. Lewis case, those are the precedential cases that are to be applied that would give our individual legislators the standing that they need to enforce their rights that derive directly from the United States Constitution.
So that was a great summary of what standing is, right? Summary is literally a question of who can bring a lawsuit or not, right? And in this case, we're talking about whether the legislature as a body can bring a lawsuit or whether individual legislators themselves can bring a lawsuit. That's the question before the United States Supreme Court. Let's say, for example, that the Supreme Court says this lawsuit can go forward, that these individual legislators can bring this suit. What are the legal points that the court then would have to examine if the suit can even go forward?
Well, then the case would, if the United States Supreme Court believes that we have standing, then the case will likely be remanded to the Middle District Court to decide the case on the merits. And so the case on the merits then would involve whether there was, in fact, executive overreach when President Biden issued this executive order that essentially required 600 plus federal agencies to be involved in get out the vote activities in an election where he's on the ballot, whether our governor overreached when he just announced through a press release that we were moving to automatic voter registration in Pennsylvania, especially in light of the fact that there have been attempts to pass automatic voter registration in Pennsylvania and those have failed. And so what they couldn't do through the legislature, they accomplished through edict and then the Department of State. So then it would turn to a question of the merits, whether in fact they have exceeded their authority as members of the executive branch.
So in talking to conservatives, right, one of the big threats, one of the big risks that we've seen really from 2020 on forward is the use of government resources in get out the vote activities that are applied in a partisan way. Conservatives are talking about this, but this is the only lawsuit that's been filed so far. Heather, why is that?
Well, that's a great question, but I think a lot of it does revolve around this issue of standing. Individual voters, right? So grassroots organizations that are opposed to this, are told, well, there's nothing you can do. You don't have standing. Secretaries of state have said, well, we'd love to bring something, but we can't get any records of what they're doing. So we can't prove an injury. And so this absolute lack of transparency is almost like a legal strategy, right? So if we don't tell them what we're doing and with whom we are doing it, then we're withholding records that they would need to be able to assert an injury. But in this case, what's unique here in Pennsylvania is that we are one of the states that passed a law that said we don't want these third parties. And the language of the law in Pennsylvania explicitly says that third parties cannot participate with the government. And the other thing that's really great in our law that works in our favor is that it says that the only funds that can be used by the government are those that have been lawfully appropriated. And one of the things that in the Middle District of Pennsylvania, when the federal defendants responded, they acknowledged that no funding had been appropriated for this, and they acknowledged that Congress had not authorized this. But they then asserted that they didn't need any authorization to do so, that they could just do it. And so I think that part of that again, this impediment, this standing issue, is really a hurdle. So everybody can look at this and say this is absolutely wrong. It's absolutely wrong. But I wanted to just kind of follow up a little bit. People are saying, because we're in the process now, we have this case pending. We're very anxious, eager for people to file amicus curiae briefs with the court to, put their own perspective on this, to show the court how important this issue is. And, so there's apparently this issue, this idea of individual legislator standing is like a controversial issue, even, in conservative circles. But here's the thing, I think that the idea and the concern is that, if individual legislators have standing, there'll be like millions of lawsuits all over the place. But but that's not at all what we're asserting. We're applying the very narrow, sort of I don't know, criteria, I guess you would say, of Coleman, and we're saying, okay, here we have not an institutional injury. It's not, because for an institutional injury, every member has to be injured equally. And the fact of the matter is, the people who support President Biden, the people who are going to benefit from, fair fight, doing voter registration drives, are pretty excited about this. They don't have an injury. So, the bar can't be that high. The other thing too, the other criteria in these Supreme Court cases that we're relying on is the idea that that the number of legislators, so it's not the whole body, but the number of legislators should be sufficient to enact or to defeat legislation. Well, we already have that here. The laws have been enacted. And in the case of, and so then one of the questions that we're posing to the court when it comes to standing and applying Coleman is, what is that number? How do you figure out what is the number sufficient to defeat or enact? Because as you know, Josh, if you introduce a bill in a committee, right, and it never gets out of committee, how many people does it take to defeat that? 3, 5? In a state legislative committee, we're not talking about 50, 75, 80 people. We're talking about a handful of people, and that bill is defeated in committee. So this is a legitimate question for the court, and there are a lot of people that are saying, well, it's going to open the courthouse doors, but it won't, because it's so narrow. And so we feel like that that the law is kind of on our side in this case, and the Supreme Court has avoided answering this question. In Moore v. Harper, they didn't address it. In Virginia House of Delegates, they didn't address it. They're really kind of just relying on this older cases of Raines and Coleman and trying to put things into one of those two categories. And we think we fit into the Coleman category.
Well, that's an excellent explanation. It talks a lot about why these cases are so hard to bring. And it's good to know that this is the Supreme Court deciding a question of law, and it's not the Pennsylvania courts just being difficult like we've seen so often. So what's the workaround? I mean, I'm sure you're talking with other attorneys that are talking about this issue, right? There's got to be other legal theories out there about how to challenge this executive order. And we don't want to give away any, legal strategies here, especially potentially winning legal strategies. But what is the workaround in this case?
Well, I mean, there's other people who there's other sort of like groups or categories of people who might have standing, right? So secretaries of state, as I mentioned, we think that there's a reason that they could object to this. I know some of them have essentially said, we're not doing it. If we get a voter registration application from a federal agency that we have not designated as a voter registration agency, then we're not accepting it. Mac Warner has really stepped up. He's kind of leading the charge here. He's just doing great stuff. So, but then there's the idea of, okay, well, do county board of elections, would they have standing? Because now they're the ones that actually have to take these voter registrations and process them. Would they have standing to challenge this? So I think that it's a tough question, but one thing that we know for sure is that when it comes, the Constitution assigns this role to the legislature, and there's just no way that the bar is that you have to get the entire legislature to agree, because you can't get the entire legislature to agree to anything. And especially in a state like Pennsylvania, where we do have a split, then and the message that this sends, by the way, when the courts say, oh, well, these legislators can't, they can't bring a case, it emboldens further, overreach by the executive branch if there's nothing to throttle them back. And so in the Supreme Court in Moore v. Harper said, well, hold on a second, the Constitution gives this power, this duty to the state legislature, but we, as the courts, as the judicial branch, still have to keep them in check, right? So we're saying who's keeping the executive officials in check, especially when they're going, they're going flat out rogue in Pennsylvania.
That's right. No, and one thing that I want to back up to about this, right? The question of who is keeping the executive branch in check. One thing that I just really want to spell out for our listeners about the difficulty of this, right? So the question is, Biden puts in this executive order, right? We want to find out what the executive order does, right? The government, of course, doesn't give over any information. They have a process. So we have to make a FOIA request, right? It's a Freedom of Information Act request where we have to request government records about how this order is being implemented. The government doesn't give those over. They give over versions that are so redacted that it's not even helpful, right? So you have to sue, first of all, to get a record of what the executive order is doing, right? And then from there, once you have that information, then you can decide whether to sue to challenge the executive order in the first place. So I think this is some liberal lawfare at its best, right? Bogging everything down in procedure here. What hope do we have for 2024 to get, some of this executive order overturned?
I think Congress has the ability to do something about this. And it's my understanding that some congressional hearings may be held soon on the issue of this executive order. I heard that in a podcast. It's not been confirmed. I don't know if Heather has any additional information. But Congress has the ability to get their hands on these documents that are being withheld. And I know that the FGA, the Foundation for Government Accountability, they instituted some litigation against the Department of Justice when they issued FOIA requests and the Department of Justice refused to cooperate. And the court actually did require the Department of Justice to provide documents, but they were heavily redacted, and I'm not sure they really received a lot through those requests. But Congress has the ability to get their hands on those documents by issuing subpoenas, by having some congressional hearings. So I'm very hopeful. And as I said, I haven't confirmed that. I heard someone say that, but I'm hopeful that there will be some congressional hearings that are held. And my other hope is that the United States Supreme Court will agree to hear this case. And Justice Clarence Thomas issued this dissenting opinion on a Pennsylvania case following the 2020 election. The case is the Republican Party of Pennsylvania versus DeGraff and Reed case. And essentially, the United States Supreme Court denied certiorari, so they denied taking the case, and Justice Clarence Thomas was very upset about that, and he issued this beautiful dissenting opinion. And we've used it quite a bit in all of our legal filings, because basically what he says is our case in a nutshell. So he said, if these non-legislative officials have the authority that they say they do, then we need to say that. But if they don't, we need to say that too, because what is resulting is confusion. And we've got these conflicting rules, and we saw it happen in the 2020 election, and we will undoubtedly see it again in the 2024 election. And the Supreme Court needs to take a case like our case so that they can definitively issue a ruling on the ability of the executive branch to change the rules in the middle of the game, especially in light of the constitutional requirement that it's the legislature that should set the rules with regard to our elections.
Yeah, that's perfect. That's really helpful. We've had Chairman Brian Stile of the House Committee on Administration here as a guest on the podcast, and we've talked about just the impact that those hearings have had, and I think that would be a good tool to kind of bring some of this executive order out into the light. So you've been incredibly generous with your time. I'd like to switch gears for 1 minute just before we wrap up here. Aside from this lawsuit, tell me, what do we need to be aware of in 2024? What are going to be the election integrity issues that people are going to be talking about in December, a month after the election?
I have one thing to offer, and then I'm sure Heather has a lot to say. But in our lawsuit, one of the things that was turned over to us in our filing in the Middle District Court was an indication of how the automatic voter registration is being implemented in Pennsylvania. And so they showed us previously when under the motor voter laws, when you go to the DMV, you would see a screen, and the first screen would say, what language do you prefer? And there were about, I don't know how many, maybe 30 languages to select from. And then it would move you to the second screen. And the second screen asked one question: are you a U.S. citizen? If you answered no, you were exited from motor voter, no other questions. Well, that's no longer the case. So according to documents produced in our lawsuit by the Department of State, now when you go to the DMV and the screen comes up and the first screen says, what language do you prefer? Now there are many, many more languages, but then the second screen that asks, are you a U.S. citizen? If you say no, you are no longer exited from the motor voter. So now you are taken to another screen, and on that screen it asks you, are you sure you don't want to register to vote? And if you say no, I'm not sure, so no, I'm not a U.S. citizen, but no, I'm not sure, I don't want to vote, there's no indication of where you go next. So there's no prompt. I don't know what happens on that screen, so I think that that's going to be the issue in the 2024 election. I think that we're going to have to to do something to keep illegal aliens from voting in our elections, because I think that they're setting the stage, at least in Pennsylvania.
Oh, I think that's exactly right, Karen. We need to do a podcast on this, but recently there was a coalition and a big press conference at the U.S. Capitol on only citizen voting, and the Texas Public Policy Foundation was one of the founding members of that, and I know y'all have been founding members as well. I think only citizen voting is going to be a huge issue in 2024. Heather, what else do we need to watch out for?
Well, again, I want to just sort of echo this issue of non-citizen voting in Pennsylvania. We are one of only a handful of states that do not require voter ID, but Pennsylvania also, as we bring up in our case, the Department of State, through a directive, instructed counties to register people even if they provide invalid ID. So we have folks on the voter rolls that have never provided valid identification. So obviously that's a big problem here. But one of the things that really concerns me is this issue of sort of this propaganda machine about threats to election workers. And I think that there's a reason, there's a motivation there, and I worry that it is an effort to kind of scare people away from being poll workers or poll watchers. And then I would also be concerned about the possibility that it would be attempting to suppress the voter turnout for, in-person voting. I mean, if you think about this, in COVID times in 2020, they were like, well, you can vote in person, but, you need a mask and you need hand sanitizer and you might die, but if you want to vote in person, you still can. So now for the last 4 years, they've been talking about this, like, threats to election worker, and just over and over and over again talking about how, but then when you get down to it and you look at like the DOJ statistics, nationwide since 2020, it's like 13 prosecutions. And many of those prosecutions, they'll admit, were people across the country sending direct messages that were, threatening or, somewhat, aggressive direct messages on, Instagram. And so, when you talk to the actual people, when you talk to the election workers in the county, they're like, well, I've heard a lot about these threats to election workers, but I haven't been threatened, but I've heard a lot about it. And I just really worry about that, because that's not our experience. When you talk to the election workers, the poll workers, it's not the issue that that this propaganda machine is trying to make it out to be, and it really worries me.
Now, Heather, that's a good point. I know we've talked about this previously, but last election cycle at the RNC, we put 80,000 new poll workers and poll watchers in place. And the big narrative around putting all of those folks in place was that they were going to disrupt elections. They were going to cause violence to election workers. They were going to do all of these terrible things. Of those 80,000 people, do you know how many incidents were reported about them? 0. There were not any. It's not to say that bad things don't happen. Articles, they do cite cases where things happen, but it's just not as widespread as people think. And poll watchers, and this, poll workers and poll watchers just play essential roles in observing our elections. Karen, Heather, thank you for your time. I appreciate it. Where can people go to follow this case and find out more about the Election Research Institute?
Yeah, so we have a case tab on our website, electionresearchinstitute.org. There is a case tab at the top of the screen. You can look at some of our case documents, press releases, and as we continue through this process, we did file a notice of appeal in the Third Circuit. That's sort of our backup plan if the Supreme Court doesn't grant. So we intend to follow this through and do our part. And again, we encourage anybody who is willing, who's following this case and willing to file an amicus. We would appreciate that. And so let's say a little prayer that the Supreme Court decides to take our case.
And I also want to add that we're being assisted in this case by Eric Cardell from Minnesota. So he has a website where you can also go to read about this case. And so his law firm is Mormon, Cardell, and Erickson. So if you go to their website, you can also find out more about this case.
Thank you so much. Eric Cardell is a good friend and an excellent lawyer. So you're in great hands for sure. Thank you so much. This is Josh Findlay with the Texas Public Policy Foundation's National Election Protection Project. And this is our Election Protection Podcast. Thank you.